Notwithstanding what I've heard from our mutual friends, I am gravely concerned in listening to your testimony, the degree to which you sound like you're still representing Donald Trump as his lawyer.
Watch Senator Adam Schiff calmly, methodically, and relentlessly pull apart Trump attorney Todd Blanche's testimony.
Your criticism of the department, for example, filing a superseding indictment in the January 6th prosecution after a Supreme Court case so that the indictment would conform with that opinion, is the kind of objection I would expect to hear from a criminal defense lawyer, not the kind of statement I would expect to hear from a deputy attorney general. So let me just ask you, you have not been confirmed yet. Are you still Donald Trump's lawyer?
I mean, yes, my attorney-client relationship with President Trump remains. Yes. The cases I was representing him on, to the extent that there's anything going on like the appeal in Manhattan, I'm not part of that.
But you're still representing him as you sit here today.
Well, I mean, representing him, there's no active matters. So
correct, but you're still his lawyer.
I have an attorney-client relationship with President Trump.
And even if you're confirmed and you're no longer representing him as a criminal defendant, even then you still have continuing moral obligations as a member of the bar, legal obligations, to your former client, correct?
Like everybody at the Department of Justice with every one of their former clients.
Correct. So you'd have a continuing duty of loyalty and confidentiality when it comes to his communications, correct?
Yes.
Now, Ms. Bondi, as Attorney General, one of her first acts, established the Orwellian-sounding Weaponization Working Group. In her memo, it says that the work of this weaponization group will be supported by the Office of the Deputy Attorney General. That is the office that you will occupy. Would you agree that it would be a blatant conflict of interest as his criminal defense lawyer, as someone who has a continuing legal obligation to him as a former client, for you to participate in any of the work of that group as it pertains to the January 6th case that you represented him, or the Mar-a-Lago case where you represent him, or Alvin Bragg's office where you represent him? You would agree that that would be a very blatant conflict of interest?
I don't necessarily agree with that. There will be a conflict of interest potentially, but I quibble with the word blatant. And it
okay. I mean, take out the word blatant, but isn't it a clear conflict of interest? You've represented him in these cases. You acknowledge you still have a continuing obligation to him in these cases. How could you possibly oversee an investigation or review of the prosecutors in these cases when you handled them? How is that not the most obvious conflict of interest?
I am not saying I can or I cannot. I'm saying I'm not going to say to you today, Senator, yes, there's a blatant conflict of interest.
Well, why?
I don't know what the work is.
Well, can't you acknowledge that if you're asked to supervise cases involving your own cases, that would be a conflict of interest?
That's a very different hypothetical. Certainly.
No, it's not hypothetical. You're subject to the order of the Attorney General now to support that working group. That working group is going to look at the January 6 cases and the Mar-a-Lago case, the cases you worked on. So can you acknowledge it would be a conflict for you to oversee that work?
What I'm not acknowledging is the broad strokes you're giving it. That work, for example. There will be conflicts, and I will not violate my ethical obligations.
Well, let me just ask you with great specificity, will you recuse yourself from overseeing the January 6th case, the Mar-a-Lago case, and the Alvin Bragg case? Will you recuse yourself from the working group's supervision of those investigations?
I will follow the rules as told to me by the experts, career prosecutors in the department when it comes to every recusal.
I've heard that.
But it's true.
Well, it may be true in the abstract.
No, it's not abstract. It's true.
Well, here's the thing, Mr. Blanche, which you well know. You may very well get some opinion of an ethics lawyer appointed by the administration to tell you that you can exercise your discretion. If you believe it's a conflict, you can say you won't participate. If you don't, you can participate. So you may have discretion. So I'm asking you, how will you exercise that discretion? Will you recuse yourself from overseeing an investigation into matters where you are his lawyer? That shouldn't be hard.
You just gave a purely hypothetical, because the
No,
hypothetical you
this
described said
this
that
is not hypothetical. This is in black and white. It says,
The
and I will
recusals.
read it, I hereby establish the Weaponization Working Group, which will be led by the Office of the Attorney General and supported by the Office of the Deputy Attorney General. So this is what you're going to be asked to do. If you are given the discretion of overseeing cases in which you are his lawyer, will you recuse yourself?
It depends. The hypothetical you just described said that a career ethics attorney tells me I do not have to recuse for whatever reason. Because again, we are talking about hypotheticals. If the career Justice Department attorney says to me, you do not have to recuse yourself, I'm not going to sit here today and say that I will still say I will
Okay,
recuse
well,
myself.
I mean, that answers my question. You don't think it's a conflict of interest sufficient that you would sitting here today, tell me
That's
that
not
you
what I
were.
said.
Yeah, no, I
not what
get,
I said.
I get it. I find it remarkable where we are.
Well, you're restating something I didn't say, Senator.
No, I find it remarkable that you feel there's any world in which you could somehow participate in an investigation of people where you represented the president in that same investigation.
I didn't say that.
It would, well, if you're not willing to commit to recusal, so that means you're willing to entertain supervising that work. So that tells me something. But let me move on, because I think you've made your position clear. Let me ask you very specifically about the Mar-a-Lago case. The Justice Department formally had recommended Volume 2 be made public. Do you support Volume 2 of the report being made public?
No.
Okay. Do you commit to preserving the evidence in both those investigations?
I commit for sure to following the law and following the rules.
But you won't
of the
commit to
Department of
preserving the evidence. Let's say you have the discretion about destroying the evidence. Do you commit today to preserving the evidence in both those cases?
I commit to following the law.
And if you can't commit to preserving the evidence in those cases in which you were the defense lawyer, I think, again, that speaks to the conflict of interest that you have as the president's defense lawyer.
I did not commit to it. I said I would follow the law.
No,
I'm not sure. I'm not sure what.
Mr. Blanche, I understand everybody's going to say generically they'll follow the law. But I've asked you a simple question about whether you will preserve evidence, and you can't say yes.
No.
You can't say yes.
I hope every single DOJ attorney, political, career, or anybody, would say they would follow the rules as a
And I would hope that any DOJ attorney will say, I will always preserve evidence. There's no circumstance in which I will destroy evidence. That's what I would hope. Mr. Chairman, I yield back.
And this is the part that should make everyone uncomfortable. Not just Democrats, not just Trump critics, but anyone who still believes the justice system is supposed to be something more than a loyalty test. Because what Adam Schiff exposed here isn't just Todd Blanche's evasiveness. It's a philosophy, a worldview where ethical guardrails are treated as suggestions, where conflicts of interest are something you manage instead of something you avoid, and where proximity to power seems to override basic professional responsibility. Think about how low the bar was. Schiff wasn't asking Blanche to admit wrongdoing. He wasn't asking him to condemn Trump. He wasn't even asking him to take responsibility for past actions. All he asked was this: will you recuse yourself from overseeing investigations into cases where you were Donald Trump's lawyer? That's it. A yes or no question that any ethics manual, any law school classroom, any serious legal professional would tell you has an obvious answer. And yet, Blanche couldn't say yes. Not because the question was unclear, not because the scenario was hypothetical, but because saying yes would close a door he clearly wants left open. And that should terrify you. Because what that tells us is that the so-called weaponization working group isn't about fairness or accountability. It's about power. It's about control. It's about creating just enough ambiguity that the people overseeing the justice system can decide, on a case-by-case basis, whether rules apply to them. Adam Schiff understood exactly what was happening, which is why he refused to let Blanche retreat into legal abstraction. Every time Blanche said, "It depends," Schiff translated it into plain English. You want discretion. You want the ability to decide whether investigating your former client is a conflict after you're already in the position of authority. That's not ethics. That's damage control. And here's the bigger picture that makes this moment so important. This is how democratic institutions erode without a single dramatic collapse. There's no one day where the rule of law ends. Instead, It's chipped away by people who insist they can be trusted while refusing to bind themselves to clear rules. What Schiff did was force that erosion into the open. He showed us how power reshapes language, how blatant conflict becomes potential conflict, how recusal becomes, "I'll consult experts," how accountability becomes a future conversation that never quite arrives. And make no mistake, if this had gone unanswered, if Blanche's testimony had slid by without scrutiny, it would become precedent. The next nominee would push a little further. The next working group would claim a little more authority. And eventually, the idea that prosecutors should be independent from the people they investigate would feel negotiable. That's why Schiff's persistence mattered more than Blanche's answers. Because even when Blanche refused to commit, the exposure itself was the point. The public got to see the hesitation, the deflection, the unwillingness to draw a bright ethical line. And once you see that, you can't unsee it. This wasn't a political ambush. It was a stress test, and Todd Blanche failed it. So when people tell you these hearings don't matter, remember this moment. Remember how close we came to normalizing the idea that a former defense attorney for the president could oversee investigations into that same president's alleged crimes. Remember how calmly, how methodically, Adam Schiff laid out the danger. Because democracy doesn't just depend on elections. It depends on whether people in power are willing to say, "I shouldn't be involved in this." And when they whoa, someone has to force the question. If you care about an independent justice system, if you think ethics should be more than a talking point, and if you believe accountability shouldn't bend for anyone, then this exchange should stick with you. Let me know what you think in the comments. Do you believe recusal should have been automatic here? Or does this kind of discretion worry you as much as it worries me? And don't forget to like, subscribe, and share, because these are exactly the moments that shape what kind of system we end up living under next. This story isn't over, and neither is the fight over who the law actually serves.